and give their attention to the court now sitting.
Thank you. Please be seated. Good morning and welcome to the Supreme Court of Kansas. I see we have a few guests in the back. I wonder if the leader of that group could stand up and announce who they are and where they're from.
Good morning. My name is Chris Guston. I'm a business teacher at Royal Valley High School, and this is my business law class. So thank you for having us.
And is anyone there prepared to make a presentation this morning?
No.
Well, welcome. Thank you for coming. Before we proceed with the reading of the docket, I have two short announcements to make. The first is that Justice Moritz is recused on the first case this morning, and replacing her on this case is a jurist to my far left. This is the Honorable Van Hampton of the 16th Judicial District. He sits primarily in Dodge City. He has read counsel's briefs. He'll be participating in oral arguments, as well as the case conference this afternoon and the ultimate resolution of the case. Judge Hampton, on behalf of my colleagues, I want to thank you for helping out the Supreme Court today.
Thank you. It's an honor to be here.
Thank you. The other brief announcement is that around 10 o'clock this morning, I need to step down from the bench and will be gone for perhaps 20 or 30 minutes. So if you are one of the lawyers in the audience who will be at the lectern at that time, pay no attention to the man who's disappearing. I promise you I'll be back, and Justice Lukert, as a senior associate justice, will preside in my absence. Having no more announcements, Ms. Green, as the clerk of the appellate courts, we do the honor of calling this morning's docket. I now call the first case on this morning's docket. That is case number 103176, Stanley L. Shrader v. Kansas Department of Revenue.
Again, may it please the court, my name is John Schultz, and I'm appearing on behalf of the defendant appellee, Kansas Department of Revenue. I would request that I be permitted to reserve 3 minutes.
3 minutes granted.
Thank you, Your Honor. I'd like to start out my argument with just a very brief procedural history. The plaintiff in this case was seen by an officer while he was operating his vehicle with a suspended license. He then turned without using his turn signal and was stopped by the officer. Now, based on the odor of alcohol, plaintiff's admission to having consumed alcohol, and numerous other factors, the officer believed that plaintiff was operating his vehicle while under the influence of alcohol, and then plaintiff refused to perform any of the field sobriety tests, also refused to perform a PBT. Before being asked to submit to a plaintiff was then arrested for driving while suspended and placed in handcuffs and taken into the sheriff's department, where the officer asked him to submit to a breath test. Now, prior to asking him to submit to a breath test, the officer did in fact provide him with the implied consent advisories. Now, particularly paragraph 7 and paragraph 8 of those implied consent advisories are read to the plaintiff, and he's put on notice that refusal to submit to testing may be used against the person at any trial on a charge arising out of the operation or attempted operation of a vehicle while under the influence of alcohol or drugs or both. And then number 8 says, the results of the testing may be used against the person at any trial on a charge arising out of the operation or attempted operation of a vehicle while under the influence of alcohol or drugs or both. The plaintiff refused to submit to testing. After a trial to the district court judge found, first, that the officer had reasonable grounds and probable cause to believe that Shrader was operating a vehicle while under the influence of alcohol. The court went further and said, after establishing reasonable grounds and probable cause, the officer was justified in arresting Shrader and transporting him to the sheriff's officer. Those are the specific findings made by the district court. Now, the plaintiff appealed.
Counselor, just because the officer could have doesn't mean that he did.
Did what? Place him under
arrest for driving under the influence.
No, he arrested him for driving while suspended.
Your brief has a lot of argument in there of what would have provided probable cause to arrest for driving under the influence, but I see the issue as whether the officer did arrest for driving under the influence when the officer said, no, I arrested for driving while suspended.
That is correct. There's no dispute with the fact that he did, in fact, tell him that he was placing him under arrest for driving while suspended. But the real issue isn't whether or not he was under arrest. It's whether or not the officer had reasonable grounds or probable cause to request that he submit to testing. That's what the clear demarcation in these cases need to be made.
How do you relate that back to the plain language of the statute?
Which statute?
Well,
81001 is the statute that the plaintiff is challenging. And generally speaking, that is a redundant statute. And that's specifically what the counselor court found. And if you look on at the counselor case, specifically on page 158. There the court says the reinterpretation of statute, or the interpretation that's been given by this court, the Court of Appeals panel in Shrader, would render wholly redundant the requirement that the officer have reasonable grounds to believe the person was operating a vehicle while under the influence of alcohol. And the reason that they say it's redundant, and it's very clear once you look at the statute, if you break it up and break it apart a little bit, it is redundant because under the first portion of the statute, the officer is required to ask the person to submit to testing if they have reasonable grounds to believe they're driving under the influence of alcohol. The statute subsection B states, a law enforcement officer shall request a person to submit to a test or test deemed consented to under subsection A, 1, if the officer has reasonable grounds to believe the person was operating or attempting to operate a vehicle, and the very next phrase, while under the influence of alcohol or drugs. Now, officer's already established that he has reasonable grounds. Now, he's required at this point, because the statute says he shall ask them to submit to a test. So, we've already determined that he has reasonable grounds at this point. He's required then to ask them to submit to a test. Now, obviously, these are tests to take him into custody or place him under arrest in order to get him to come in and take the test. And then the statute goes on, and any one of these conditions exists. The person has been arrested or otherwise taken into custody for any offense involving operation or attempted operation of a vehicle. The officer already has the idea that the person is operating under the influence of alcohol. Why does he have to meet this redundant statement again and say, oh, now you're under arrest for driving under the influence of alcohol and drugs?
Do you want us to rule upon the logic of the statute? I mean, we don't typically do that. If the legislature makes it redundant, then the legislature makes it redundant. And how do you get away from the plain language, and one of the following conditions exists? That's a conjunctive, and specifically, I don't see how you read that without seeing a legislative requirement, redundant or not, that there be an arrest or custody or taken into custody for the driving under the influence.
Well, if you read that all as one phrase, that's correct. But if you stop after arrest in the language of that statute, under arrest, or in the alternative, they're in custody for an alcohol-related offense. Now, if the officer already has reasonable grounds and a person is placed under arrest, shouldn't make any difference whether they're under arrest for driving under the influence of alcohol or just for an offense involving the operation of a motor vehicle. Now, if the court looks at 81002, which is really the statute that controls, because that statute deals solely and specifically just with the driver's license suspension case. And the language in that case is much different, because there, 81002 says, there existed reasonable grounds to believe the person was operating or attempt to operate a vehicle while under the influence of alcohol or drugs or both. And then I'll skip all that. It goes to subsection B. B, the person had been placed under arrest, comma, was in custody or had been involved in a vehicle accident or collision. That statute has none of the language with regard to while under the influence of alcohol or drugs. None of that language exists in that statute. That statute is, in fact, more specific, and it's more applicable to this particular case because this is not the criminal case. This is the driver's license suspension case. And 81002 is very clear that that statute gives the department the authority to act. Under subsection B of that statute, it says for purposes of this section, the officer's certification, the DC-27, shall be complete upon signing, and no additional acts of oath, affirmation, acknowledgement, or proof of execution shall be required. The signed certification or a copy or photostatic reproduction thereof shall be admissible in evidence in all proceedings brought pursuant to this act, and this is the important part, receipt of any such certification, copy, or reproduction shall accord the department with authority to proceed as set forth herein. So it's very important. That is, in fact, the controlling statute. 810.01 is much more general in nature. It has provisions that affect the civil case. It also has a lot of provisions that affect the criminal case.
Counsel, I didn't see that statute cited in any of your briefs. Did I miss it?
It was cited, a portion of it was cited, and the confusion that has arisen with regard to these statutes, originally we had 810.01 and 810.02. Those pretty much incorporated all of the act. Over the years, those have been amended and changed, and then now we have 810.20, which deals with more of the procedural part, and so these statutes have been gutted and kind of switched around. A lot of the provisions have come in and out. But no, we did not initially cite that in the brief, this particular portion of the language of the statute. And I don't know whether, honestly, the counselor court considered that or not. It was the exact same language when counselor was decided. And it's never been changed all these years that it's been modified. That portion has never been changed.
To my memory, the first time it was, presented to this court was in your 609 letter, which we got yesterday. Is that right?
That is correct with this particular language. But I think it's important. And
well, let me follow up if I may.
Very well.
Did this statute just come into existence this week?
No, it did not. It has been in existence for some time.
And what is the explanation for why this argument was not made till yesterday?
Your Honor, we just missed it. Mr. Keller and I try numbers of cases, and Mr. Keller does lots of briefs on them. We try to refute the allegations that are made by the plaintiff, and sometimes we just get sucked in and we get tunnel vision. We were focusing so much on 810.01 and the fact that counselor has been good law for all these years that we simply didn't even look at 810.02. But frankly, if the court's going to look at the statute and try to determine what the legislature's intent is, it's got to look at all the statutes. And that includes 810.20 because there's language in 810.20 that mirrors the language in 810.01.
And if opposing counsel tells us, I'm not ready to respond to counsel's argument because I just got this argument yesterday, what are we to do with that?
Well, he has the right to file a response, and I certainly have no objection to the timing of his response.
We're conferencing the case this afternoon.
I understand that, Your Honor, and I appreciate the court's concern with that. Unfortunately, again, we're looking at a statute, and I feel duty-bound to bring to the court all of the information I have with regard to this appeal so that it can be decided properly and the court has all of the information available to me and to the court.
Well, from a practical matter, I'd be interested in how you think we should solve this problem. Should we just hold off on our case conference till counsel does get a chance to send us a rebutting or responsive 609 letter?
I have no objection to that, Your Honor. If the court wants to grant the plaintiff additional time, I'd have no objection to that. Mr. Walter and I have worked together for a number of years, and we're always very cordial with one another about granting extensions of time and getting additional time. I do appreciate the problem that I've caused with this short notice on the letter, the 609 letter. Unfortunately, I had a couple of cases, the Olson case that just came down last Friday. I wanted the court to be aware of that case as well. And that's kind of a for whatever it's worth case. It was a case that was decided by the Court of Appeals on this identical issue, but that panel, the Court of Appeals, chose to follow counselor, and the particular panel in Shrader did not. So I think it's important for the court to have all that information in order to make an adequate decision. I mean, this is the court of last resort on this issue, and I really want the court to get it right.
Your position throughout this litigation has been that counselor controls, is that right?
That is correct.
And that's your position today? That
is correct.
And where did the Court of Appeals in this case get it wrong?
Where did they get it wrong? I think they got it wrong because the Court of Appeals in this particular case made the findings, number one, that the officer had reasonable grounds. And once they make the finding that the officer has reasonable grounds, then they expand the issue. Because if you recall, the plaintiff, in his initial appeal brief, he agreed that counselor was good law, agreed that it was settled law. His brief on page 5, he says, plaintiff states that 810.01 was construed in State v. Counselor not to require an arrest for an alcohol or drug-related offense. And then the court, he narrowed the issue further before the court to whether or not the plaintiff was arrested for an offense involving the operation or attempted operation of a motor vehicle. So that's where the court then went wrong, is the court then expanded the issue and said, well, we're not going to narrow the issue to what the plaintiff raised. We're going to go all out and we're going to expand this issue. And the court then further went wrong and said, we're going to reconsider this case because we don't like the language. And the court then said, there's other case law out there that supports this reading of the statute. And I'd like to point out that those cases are not precedent. They provide absolutely no support for the argument made by the Court of Appeals to overrule Counselor. In Sullivan, the sole issue was whether the officer...
Before you get into those, Counselor, I just want to see if I understand. You're asking us today to consider your 8-1002 argument, acknowledging it wasn't raised or decided, wasn't raised before the Court of Appeals and wasn't decided by the Court of Appeals. And so we wouldn't be reviewing a Court of Appeals decision on that issue. Would you agree that that's
Well,
the
if the court has
circumstance?
unlimited review when it comes to regard to a statute,
Is that correct?
that is correct. I don't know what the court considered because
but your argument you just made was the Court of Appeals should not have expanded their consideration beyond the portion of the statute that you wanted considered. I don't understand why sauce for the goose isn't sauce for the gander.
I'm sorry, I didn't understand what you said.
I understood you to argue that the Court of Appeals went astray when it decided more than was briefed by the appellant, but you're wanting us to decide more than was briefed by you. How do you...
It's all part of the statutory scheme, Judge. I mean, you have to look at all of the statutes in paramateria, and if this court is exercising unlimited review in its review of a statute, unlimited to me means look at all the statutes that are going to have an impact on the court's decision.
Is that our what we do on a petition for review? We review de novo, unlimited, the whole case and the whole record?
Well, it's certainly my understanding that when the court is looking at the statute, at a statutory requirement, you're to determine what the intent of the legislature was. And your review is pretty much unlimited in regards to reviewing a statute and what that statute, how that statute is interpreted. I see that I'm out of time. If there are no further questions.
Any further questions of counsel? Thank you, counsel.
Thank you.
May it please the court, Daniel C. Walter, Ryan Walter in McClimate, Norton, Kansas, appearing on behalf of the appellant Stanley Shrader.
Counselor, how do you answer the argument that we are directed to construe statutes together, look at the whole act? Why wouldn't that take us to the argument on 8-1002?
I don't have any particular quarrel with what my esteemed colleague has argued about construing the entire act. In fact, that's exactly what I'm asking the court to do. However, counsel's focus on 8-1002 is misguided. If the court considers the entire act, it has to consider the plain language of 8-1001, which requires an arrest for an alcohol or drug-related offense while operating a motor vehicle. More importantly, and I've had KSA 8-1020 stuck in me more times than I care to count, I am able to cite it in favor of my client on this particular day because 8-1020 controls what issues get to be reviewed by the district court, by the Court of Appeals, and ultimately by this court in this case. 8-1020 says, if the officer certifies that a person refused a test, the scope of the hearing shall be limited to whether. And the first thing is whether or not the officer had reasonable grounds. Paragraph B, capital B, says that the issue which is to be argued is the person was in custody or arrested for an alcohol or drug-related offense or was involved in a vehicle accident or collision, etc. So whatever unclarity had been created by the counselor court. Now, I think the counselor court even addressed 8-1020, and I can't explain why they got it wrong, but that's our position today is, in counselor, the court, that panel just plain got it wrong. I'd never understood counselor when it was decided, which I think was 1995. I don't understand it today. I think when you do look at the entire act, and I have raised this in multiple briefs that I've filed, 8-1020 is the umbrella which straightens out all the other things that the legislature has fouled up in the rest of the act, and it says that one of the requirements in order to have license sanctions imposed is that the person was in custody or arrested for an alcohol or drug-related offense. That is the plain language of the statute.
Can you be
Counsel?
arrested? Go ahead.
I was just going to follow up on that. As I understand your argument, in looking at the two statutes, 1001 and then I think you said 1020, under 1001, according to counsel's interpretation, you don't have to be arrested for one of these, I'll call it a DUI offense, in order for the test to be requested. But if you're going to challenge that on appeal under 1020, you're not able to. You're only able to determine or to challenge the arrest for an alcohol or drug-related offense. Is that right?
I believe that's a fair construction, Your Honor.
So does that create a hole for, let's say, KDR to say when you raise that argument in the future, I'm sorry, that's not something you can raise on review?
I'm not sure. I have not, believe it or not, I haven't thought that deeply into it. When I walked in here today, I confessed to my colleague, I honestly don't know what to say today, except that the court got it wrong in counselor. They got it right in Shrader. The plain language of the statute requires, before the administration of an evidentiary test, that the person have been arrested for an offense involving the operation of a motor vehicle while under the influence of alcohol, drugs, or both. Whatever question mark is created by 8-1001 by failing to insert a comma between a couple of words is cleared up by 8-1020, which clearly requires an arrest for an alcohol or drug-related offense.
I'm not getting that from the language. Can you help me?
I can, Your Honor.
H1B reads, the person was in custody or arrested for an alcohol or drug-related offense. Why isn't the same argument that KDR is making as to 8001 apply to that language, which as I understand it is that this defendant was arrested for driving on a suspended license, but was also in custody for the investigation of the driving under the influence?
Well, actually, there's a question about whether or not he was in custody. I know there's language in some of the written documents that appear in this file, but the Shrader facts are really a little different than counsel.
Before you get to the facts, can we stay focused on the language of the statute? Then we can go to the facts?
8-1001, subparagraph B is what I understand the inquiry is about. Is that correct?
I was looking at 8-1020H1B, which I thought was the language you were quoting. It's also the language that counselor quoted, but at that time I think it was in 8-1002. So the very confusing switch of statutory references.
It is, Your Honor. I confess that is, in fact, correct. Mr. Schultz has argued correctly the language of 8-1002. What he fails to consider is that whatever discrepancies exist, which were created not by him, not by me, not by this court, but by the legislature, are cleared up when you get to the more specific statute. 8-1001 and 1002, I would argue, are general statutes. I would argue that 8-1020 is the more specific statute because it tells us what issues we can address in order for any court to have subject matter jurisdiction.
And that's the section I'm looking at, H1, large capital B.
Correct.
that starts with the person was in custody or arrested.
For an alcohol or drug-related offense. Counsel for the Department of Revenue has argued that a phantom comma exists between the word arrested and for. It does not. It is a continuous sentence unpunctuated with a comma. It says the person was in custody or arrested for an alcohol or drug-related offense.
And as I understand their argument, they're saying that he was not arrested for a drug-related offense here, but he was in custody for a drug-related offense or an alcohol-related offense.
He was not. What happened in Shrader was he didn't use a turn signal. The officer pulls in behind him in his own driveway. He gets out, has no problem with the exit, has no problems with balance or coordination outside of the vehicle. And I'm not making this up. This is in a video that the court has in the record. His speech was not slurred. The officer claims there was an odor of alcohol. There were no standardized field sobriety tests, no preliminary breath test, and no arrest of any kind was formally announced. In fact, Mr. Shrader asked the officer what he was being arrested for, and he told him he was not under arrest for anything. He was, however, handcuffed, which would give an indication that perhaps you are otherwise in custody. But it can be argued, as it was in the Wonderly case, which I always like to try and cite whenever I can, just because you're in handcuffs doesn't mean you're in custody. Sometimes it's for officer protection. The officer in this case told my client that he was not under arrest for anything. The only reason that you can conclude, therefore, that he had handcuffs on was for officer protection. In trial, the officer testified that even though he didn't announce an arrest and specifically told Mr. Shrader that he wasn't under arrest, that in his subjective conscience, he was under arrest for driving on a suspended license, which is not an alcohol-related offense. I don't know what happened.
I think the question is, could the officer arrest for driving while suspended, but also have Mr. Shrader in custody for the alcohol-related?
He was not in custody for the alcohol-related offense. That's what the officer said. In fact, he first told Mr. Shrader that he wasn't under arrest at all.
So we don't need to decide today whether you can arrest for a suspended license and also say that the person is in custody concurrently.
I don't think we need to address that. That was addressed in Wonderly, and I don't think Wonderly really has anything to do with this case. And
Usually in Fourth Amendment context, we use an objective standard, not so that whatever the officer thought is not really relevant to the consideration of whether someone's in custody.
Yes,
Does
Your
that
Honor.
same objective standard apply here?
Yes, I agree. And part of the objective standard is that the officer specifically told him that he wasn't under arrest. And I don't think we...
Counselor,
Yes, sir.
does the officer have to state every reason that he has for an arrest?
No, he does not.
So it's possible that he may have possessed reasons or objectively may have had reasons for an alcohol-related offense.
It's possible, except for the fact that he specifically told him that he wasn't. So if you're measuring by an objective standard, I don't know how much more objective you can get than the officer's statement to the arrestee, if you want to call him an arrestee at that point, that he wasn't under arrest. That's about as objective as you can get. I don't think we need to get to that.
But it may be an objective from the standpoint of we look at it from a reasonable person rather than subjective, but it has to be subjective to the point that the officer needs to be able to state probable cause to arrest. And so the officer has to be able to articulate facts which would give one probable cause to arrest for some offense, You don't have generic arrest.
You are correct, Your Honor. And that goes to the reasonable grounds argument. You are exactly correct. That is part of the equation. It's something that we can't ignore, but it doesn't have anything to do with this case. This case, yes.
I'm sorry. The district court found reasonable grounds to arrest or to investigate driving under the influence, wasn't
Correct,
there
Your
that
Honor.
specific finding?
Correct. However, the problem is that Mr. Shrader was not under arrest for an alcohol or drug-related offense. In Counselor, the facts are a little different. In Counselor, the driver was taken into custody, and between the time he was taken into custody and the time that he was asked to submit to an evidentiary test, the officer acquired additional information which formed reasonable grounds. In this case, all the information was obtained at the scene. There wasn't anything additional that the officer acquired between the time he put Mr. Shrader in the patrol car and the time he got him to the law enforcement center and asked him to submit to an evidentiary test. I don't think we need to get any farther than deciding whether Counselor is right or whether Counselor is wrong. I believe, and I believed at the time it was decided in 1995, that it was wrong. I never understood it then. I don't understand it now. Shrader is, as decided by that particular panel of the Court of Appeals, is exactly correct. There has to be an arrest for an alcohol-related offense. There is a much more subtle issue upon which this case could turn as well, and that is this. If we want to entertain the notion that perhaps an arrest for any offense involving the operation of a motor vehicle is sufficient, I would argue that a subtle distinction can be made between those offenses which involve things such as moving violations and the arrest that occurred in this case, if at all, which was for a status. Didn't really involve the operation of a motor vehicle, the mechanics of actually driving the thing down the road, turning it left or right, or keeping it between the curbs. This was a status offense. This was not an offense involving the operation. I have no more to say. I'd be glad to answer questions.
Do you have a response to opposing counsel's argument that we have a redundancy in 1001?
I have a position on that. I believe he's wrong. I think there have to be reasonable grounds, and there has to be an arrest for an alcohol or drug-related offense. That's not a redundancy. It's two separate things. And I did want to mention at the beginning of my argument, I don't want counsel's letter that he filed yesterday, and which I did receive, to become an issue in this case. It shouldn't hold up deliberation on this case. I don't intend to respond. I don't object to the court considering it. I just don't think it has anything to do with the case.
Very good. Thank you.
Thank you.
Any further questions of counsel? Thank you, counsel. Reserve 3 minutes for rebuttal.
Thank you, Your Honor. The question as to whether or not the plaintiff was under arrest or was otherwise in custody was resolved by the district court. The district court specifically found at page 74 in his memorandum of decision, it would be page 74 of volume 1 of the record. The court states, although the plaintiff questions whether he was under arrest or otherwise in custody, it is clear that he was. Now, plaintiff hasn't again appealed from that finding. The plaintiff's only appeal was that he was only arrested, or he was not arrested for a driving error. It was only a status offense, as he's informed the court today. There's no question that the plaintiff understood that he was being arrested. He asks on the video, why am I being arrested? He also said, just go ahead and take me in. The officer's belief that he was placing him under arrest is clear. My question at this point is, who has to know they're under arrest? Obviously, the plaintiff knows he was under arrest. Not only did the officer tell him by putting the cuffs on him and transporting him, obviously he knew he was under arrest. Then the officer read the implied consent advisories. And in State v. Scott, which is cited in our brief, that is an Oregon case, almost identical circumstances came up. They have a little bit more of a restrictive statute than we do. But the court held that when he was asked to take the intoxilizer test, he'd been advised that DUI was a crime, that if he refused to submit to the breath test or failed it, evidence of refusal or failure would be admissible against him. They found that satisfied any requirement that the plaintiff be under arrest. He was informed of his rights and given some information with regard to what was going to happen with that test result. Now, going back to my other arguments, the Court of Appeals reversed the trial court and decided that a case that was decided in 1996, Counselor's been on the books for a number of years, and it's been followed in numerous cases. It's been cited by this court in the Brook case and some other cases with approval. It's been followed by forever. In Miller v. Johnson, this court recently states with regard to the doctrine of stare decisis, maintains that once a point of law has been established by a court, it will generally be followed by the same court in all courts of lower rank in subsequent cases when the same legal issue is raised. Finally, it says, a court of last resort will follow that rule unless clearly convinced it was originally erroneous or is no longer sound because of changing conditions, and that more harm will come by that more good than harm will come by departing from the precedent. And that court is citing Roten versus Dickinson, 290 Kansas at page 92.
But interestingly, that case declined to follow precedent, didn't it?
In that case, it did. But the court did announce rules, and there were some good public policy decisions and reasons in that case for declining to follow the rule. Here, there are none of those.
And here, do you have any authority of this court that you rely on for that rule? You're relying on a Court of Appeals decision, isn't that correct?
Well, this was cited by the court recently in Miller versus Johnson.
I know, but here we're talking about Counselor.
Counselor was Court of Appeals
decision.
Correct.
So none of that language applies here because that was a lower court, and we have split panels of the Court of Appeals that we're reviewing.
I understand, but that this court has cited Counselor and Hulsman with approval in the Brook case and in several other cases. I can't think of them right off the top of my head.
Not on this proposition, though. Not on this proposition that's before us today.
It cited the same language that the person can be either arrested or in custody, and they don't even have to be under arrest in order to request a test. It sort of cited that same language out of Counselor, which was then repeated in Hulsman, and was cited several times by this court I know in Brook, and I believe Hulsman was also this court's decision, but I don't recall right off the top of my head.
Counsel, no, go ahead.
If we don't agree exactly with your reading of the statute, but some kind of a hybrid of what you've talked about, in other words, if we don't say that the person was in custody, as you have suggested in some of your argument, but instead say the person was in custody for an alcohol or drug-related offense, that prepositional phrase modifies custody.
That's clear. That is a clear reading, plain reading of the statute. And I think that's the way the Counselor court was reading it, that they're in custody for an alcohol-related offense.
But there were no findings of that in this case, were there?
Specific findings by the district court or by the Court of Appeals?
By the district court, who would make the findings of fact.
That he was arrested or otherwise in custody?
That he was in custody for an alcohol-related offense.
Well,
He made a finding that he was in custody.
The court's specific statement is that after establishing reasonable grounds and probable cause, Officer Burmaster was justified in arresting, cuffing, and transporting to Shrader, to the Decatur County Sheriff's officers for purposes of completing the paperwork necessary in order to request that the plaintiff submit to an Intoxilizer 8000 test. Now, the court says he obviously has reasonable grounds of probable cause, and that he was justified in arresting, cuffing, and transporting. Now, whether or not that is implicitly makes a finding is the judge doesn't say he was under arrest or he was in custody. So I think the judge uses those terms interchangeably because his reading of Counselor agreed with us that it doesn't really make any difference.
Do you have a citation to the record available?
Yes, that would be in Record Volume 1 at page 75.
Thank you.
First paragraph.
So you're saying it's permissible. Let's forget about the driving while suspended. You're saying it's permissible to stop someone, have reasonable grounds to believe that they're operating under the influence, handcuff them, put them in the patrol car, take them to the police station, and all the while they're not arrested, they're simply in custody for an alcohol-related offense?
That's correct. Happens every time there's a DUI check lane. That's what happens. They pull into the check lane, officer stops, asks them, have you consumed any alcohol today? If they say no and the officer doesn't smell it, they're free to go on their way. If they say, yes, I've consumed some alcohol, officer gets them out of the vehicle, has them perform field sobriety tests, takes them into the BAT van that's usually sitting right there on the side of the road. They perform the test. If they pass the test and they don't blow over 0.08 or 0.02 if they're under 21, they're free to go. They've never been arrested. It's only after they complete that breath test that they're placed under arrest, because the officer doesn't know that he has any authority to arrest them for a crime unless he knows that they've got a breath test result at that point. And that's the other problem that we have in this case is, again, with the blood test delay. Now, obviously, we can have a problem with the blood test, but again, I think that's what the implied consent law says, is that you impliedly consent to let us test your breath or blood.
But you don't consent to be handcuffed, put in the patrol car, and taken someplace else away from your vehicle for an investigatory purpose, do you?
That's correct. And you give up that right to refute, or you give up that right when you get in a vehicle and exercise your privilege to drive. And if you drive under the influence of alcohol and an officer has reasonable grounds or probable cause to believe that, it's the officer's duty to place you under arrest.
Well,
or to take you into custody.
Well, there's a difference. I mean, for arrest, we have statutory requirement that there be probable cause.
Correct. In the criminal case. But in a civil case, that's a little different. All the officer has to do is have reasonable grounds to believe the person is operating under the influence of alcohol. Finally, where I left off, I would like to point out that the cases cited by the Court of Appeals as precedent in support of its decision are not precedent. The Sullivan case, the only issue...
Counsel, I think you've made that point in your earlier remarks. Do you have anything else for us?
No, I do not. That concludes my argument. Well, one thing. The only other thing, Judge, is that the other thing that I don't think that the court in Shrader considered at all, that the court in Counselor did consider, was the remedial nature of these statutes. This is, in fact, remedial law. That was a point was made of that in the Counselor decision. There's absolutely no mention of that by the panel in Shrader. Thank you all very much.
Any further questions of counsel? I see none. Thank you.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.